Welcome back, everybody. My name is Tom Olsen. The name of the show is Olsen on Law, every Saturday at 11 a.m. right here on News 96.5. I'd like to introduce you to attorney Michelle Berry. She specializes in family law, including divorce, alimony, child support, and time sharing. Hey, Michelle, welcome to the show.
Hi there, Tom. Thanks for having me today.
You're very welcome. Hey, I got a call from a listener, and we want to get you on the line and have you answer it for us. The call was that they have been divorced for 2 years, and now the caller is moving across on the other side of Orlando. They got a 5- and 7-year-old children. They want to know, do they need to change their time-sharing plan because they're moving to the other side of town? What do you think?
Well, that's actually the operative phrase there is the other side of town, because Florida has a statute that determines whether or not a relocation has to go back to court. The relocation is predicated on whether or not the move is over 50 miles. So unless they have something written in their own time-sharing plan that waives that provision, or they make it even a shorter distance, that's going to control whether or not you can actually just pack up and move across town without inventing the time-sharing plan, because obviously it's going to make a difference. As we know, living in Orlando, it takes more than an hour to get pretty much anywhere here, so it could be a 20-mile move across town, but it might very much influence the time-sharing, so the parents need to sit down and reconfigure how that's going to affect their children, especially with school, because that will change as well.
What would change about the school? I mean, wouldn't they still stay in the same school even if one of them decides to move across town?
Well, that can change, because depending on what the school district is, you've got your A-rated schools and you've got your not A-rated schools. And if you have a child who's going to a good school in one location and then the other parent moves, a significant distance away, they may have the option of saying, hey, this child would benefit from going to the other school. So that's usually where the litigation begins, because, of course, one parent doesn't want to give up where the child is attending and the other parent wants the child to be close to them. And that's usually the most common reason these cases are reopened.
But in a typical time-sharing plan, does it dictate where the children are going to school?
Oh, yes. It usually will be stated somewhere within the parenting plan that the district where one parent or the other will control what school is assigned. And normally the parents live close together, because that would be in the best interest of the child and, of course, for the parents to have the most time sharing. But if you have a parent who then, for instance, gets a great job offer or whatnot, goes across town, that may be a really good school in that area as well, and then that would be something that needs to be revisited, is whether or not they want to stay in the old district or allow the child to go and attend school in the new one.
Hey, I want to be clear. If the time-sharing plan says the kids will go to school in whatever district mom lives in, and mom moves across town, do they automatically then move to a different school without going back to court?
That would be the case, because, and it's funny, I had a case very similar to that just last year, that one parent moved because they got a great job, and it totally disrupted the time sharing. They lived right at the edge of Orlando out towards Windermere, and the other parent lived on the other edge of Orlando towards Apopka, and it absolutely changed the school district.
And so moving across town at a minimum is going to require one or both of the parents to have to drive farther and longer to get the kids and drop them off. How is that handled?
Oh, with a lot of aggravation by both parents. So it becomes an issue when one parent, for instance, is working at, different hours from the other, and then all of a sudden somebody can't be there to pick up a child from school. So that is why those are very often the most commonly litigated cases post-dissolution. When it has to do with children, driving, schools, those are usually the touch point to end up back in front of a judge.
Hey, Michelle, if you've got two loving parents equally good at parenting their children, what would be the typical time-sharing plan as far as a starting point, as far as the days of the week?
Normally, parents do want to split their time with their children equally, and of course, with logistics involving school and extracurriculars, that's sometimes not possible. But a parenting plan that has worked very well for a lot of my clients is where children know. Say, for instance, every Monday and Tuesday, they're at mom's house overnight. Every Wednesday and Thursday, they're at dad's house overnight. And then Friday, Saturday, and Sunday, they're with the parent that they weren't with the previous weekend. That way, the child knows where they are every day of the week, what house they're going to be at every night of the week, and that is what the court considers in the best interest of the children.
All right. Hey, Michelle, tell the listeners how they might reach you here in Orlando.
Well, my office is located in Longwood, and my web address is mbarrylaw.com, and my email address is michelle@mbarrylaw.com, and you can also reach me by phone at 407-622-4529.
Hey, Michelle, thank you for coming on the show and clarifying that for us. We appreciate it. That was attorney Michelle Barry. She's a divorce family law attorney right here in Orlando, actually in Longwood. And if you want to reach her at her office, her phone number is 407-622-4529.